Assalamualaikum warahmatullahi wabarakatuh. This is part 2 for the Zoom recorded lecture for the topic privity of contract. So in part 1, we discussed about the definition and then the position of the doctrine or the rule under common law. Now we are going to continue with the position of privity under Contracts Act 1950. Actually, if we refer to the provisions of Contracts Act, okay, actually there's no express provision. Okay, there's no specific provisions which discuss about position of privity. But again, whenever there's no provision, there's no direct provisions in the Contracts Act, we are going to have a look at the case law. So the answer is yes, okay, this doctrine is applicable in Malaysia by virtue of case law. We have few cases to be discussed. We are going to start with the old case, Kepong Prospecting Limited and Schmidt, reported in year 1968, and it was decided by Privy Council. This is when Malaysia has yet to have our federal court or Supreme Court. Okay, so whatever appeal, it will go to Privy Council. So it involved two parties here, appellant and respondent, and also actually there's also one Mr. Tan. Right. Actually, they have a agreement. Okay, agreement between them. Agreement in 1954. So it was signed between respondent, the company, and Mr. Tan. Okay, and then as far as this 1954 agreement was concerned, the appellant was not a party to the agreement. And then in the agreement, it was provided that the respondent, the company, okay, took over Mr. Tan's obligation to pay the appellant, the tribute, okay, the amount of 1%. And then later, okay, when the case was brought to the court held that with regards to privity, only the respondent and Mr. Tan, okay, because they were the parties to this 1954 contract, could enforce the 1954 agreement. Okay, other than that, I mean, they are not privy to the contract. They cannot really enforce it, even though there could be breach of contract which affect the right of third parties. As far as 1954 agreement was concerned, only respondent and Mr. Tan. So appellant was not a party to this contract, so cannot enforce it. And then some of the latest, not really latest, but then quite recent, okay, not really old case, we have a decision by Supreme Court in the case of MR Sinan Berhad under receivership and IDG Sinan Berhad, reported in year 1982. And also we have decision by Court of Appeal in the case of Lam Kamloy and Baltax Sinan Berhad 205, reported in year 205. And from both of these cases here, one by Supreme Court, another one by Court of Appeal, both cases actually apply the rule of privity. So in other words, the doctrine of privity as applied in UK, okay, actually is also applicable in Malaysia by virtue of decided cases, by virtue of case law, not by virtue of statute. Okay, let's have a look at some of the cases, which is also not very old case, quite recent, and this is important because decision was given by federal court. You can find this case in your course outline. The case name is Badiadin bin Muhammad Mahidin and Arab Malaysian Finance Berhad. So what happened between them here? This is the summary actually. Okay, if you read the full report, it is quite bulky. This is a appeal case, obviously. So it involved appellants. Who were the appellants? They were the registered co-owners, okay, of a piece of Malay reservation land. So it's not a normal land. Okay, this is a special status affixed to land, okay, which belong to Malay and can only be transferred to Malay. And then they have, because they were having some businesses, okay, and their business associate, okay, Ismail, was in need of funds, need money, okay, for their business purpose. So the appellants, the owner of Malay reservation land here, they agreed to assist Ismail, and for that purpose, they charged the land. Okay, they didn't take the loan. Okay, they are the charger. Okay, they charged their land to respondent to the bank, Arab Malaysian Finance, to secure a loan. Okay, the loan was advanced to Ismail. If you read the full report, the amount of loan was 400K, quite big amount. Okay, and then actually the charge is known as third party charge. Third party charge because why? The charger is not the borrower. So such a charge was created by the appellants, okay, in favor of the respondent is called a third party charge, okay, because the charge is not the borrower but a third party. sorry, the charger is not the borrower, but third party. So the charger security is liable to foreclosure, okay, only when the borrower makes a default, okay, on the, so whenever there's any problem in repayment later, okay, the bank, okay, the chargee has the right to foreclose, okay, to put the land on auction lah, okay, to recover the money, the loan advance. And then if you were to look closer, okay, actually there were two separate and distinct contracts. Okay, the first one, contract of loan between Ismail and the respondent, Ismail and the bank. Okay, the one, the creditor and the debtor. And the second contract was the contract between appellants and respondent. Okay, the owner of the land, contained in the annexure to the charge. And then Ismail didn't pay the loan lah. He defaulted payment. Ismail committed a breach of the loan agreement. So now the bank, the Arab Malaysian Finance here, respondent, they foreclosed the third-party security based on third-party security that they have signed, okay? And they obtained order for sale of the land. But it was actually challenged by appellant here, because when the case was brought to the court, it was found that actually it contravened, okay, certain enactments, certain rules here. And eventually it was illegal. Okay? The charge was consequently found to be a dealing prohibited by Malay Reservation Enactment. And actually it was illegal and void. And whenever we have any cases dealing with illegal and void contract, Section 66 of Contracts Act will come into play, will be relevant, because it gives the parties the right to restitution, to get back whatever they have transferred, okay, to be restored back to their earlier position. But with regards to privity, okay, we just focus our case on privity. But again, it has connection with Section 66 here. The court held that, okay, this is a decision observation by federal court. The fact that Ismail had used the loan money received from the respondent, from the bank, to pay other people. So the money, the loan money actually was used to pay, okay, to pay whatever outstanding payment, okay, including appellants. So, and this fact actually it won't affect, okay, the local the position of the parties. Okay, it could not make them parties or privy to the contract, because the loan contract was signed between respondent, okay, and Ismail. Okay, it's not the appellant wasn't a party, he wasn't privy to the contract. And then again, the court made it clear the appellants were not a party to the loan agreement. And as such, okay, there was no question, okay, of repayment by them, okay, either by way of restitution or benefit, or meaning that here we cannot really apply provision of Section 66, okay, because of the, it is connected with the doctrine of privity. In order to apply 66, okay, the parties have to be privy to the contract. They are part of the contracting parties. If they are not, then we cannot apply. We cannot restore the parties back to their earlier position. Okay, that's the provision of Section 66 of Contracts Act 1950. Okay, we have another case, right, to show the application of privity in Malaysia. This is quite recent actually, and judgment by Court of Appeal. Reported year 2017. The case name is Tan Po Hee and Tan Boon Tien and other appeals. Again, if you read the full report, it's quite bulky. So I made a summary here just in one slide. Okay, basically, it relates to a dispute between appellants. Who were the appellants here? Appellants were siblings, okay, of the deceased. Okay, the deceased was late Madam Chang. So I put here for the purpose of easy explanation, Chang. Okay, it refers to the deceased or late Madam Chang. If you read the full report, they use the term late Madam Chang all the time. And the suit was between appellant, the sibling, and respondent. Who were the respondent? Respondent was children of late Madam Chang here. So it's between sibling and children, because the late Madam Chang, together with the husband, owned certain company. Okay, and they were fighting over the ownership of the company after Madam Chang and the husband passed away. Okay, all right. Because children said they are entitled to it, but siblings said no, they are the owner. Okay, so it was a fight, okay, of this ownership dispute over ownership. And then one of the argument here, respondent claimed that, okay, the children, okay, claimed that by way of purported oral agreement. They said there was oral agreement, okay, in year 2004 between Chang, okay, and Tan, both husband and wife, the appellants and respondent. Okay, and then during the oral agreement, it had been agreed that appellants would relinquish, okay, will let go, okay, and transfer their shares in the company to only Chang and Tan, because the company was owned by Chang, Tan, and also the siblings lah, okay, her siblings. And both of them were to hold the shareholdings transferred by the appellants as trustee. For the respondent, here you need to transfer all the shares to only Chang and Tan, and then Chang and Tan would hold this share as trustee for the children, for the respondent. But after the court examined, okay, all the evidences, okay, all the all the explanation whatsoever, okay, in the court. So the finding was that, observation was that respondent actually had no privity. There was no privity in respect of an agreement. So children were not party to the agreement. Okay, so whatever arrangement, whatever understanding between Tan and Madam Chang and involving appellants here, so children were not parties to it. They didn't have any privity. Okay, so they are not, I mean, they were not a party to the for agreement, so they don't have right to sue or whatsoever. Okay, that's the finding by the court. So this is just a summary of the case actually. Okay, so we are going to continue later. We stop here for a while. I'll see you in the next part of the lecture. Assalamualaikum warahmatullahi wabarakatuh.